It's finally here, the end of the longest mischief trial in Canadian history, the trial of Chris Barber and Tamara Lich, the trial of Tamara and Chris. Unbelievable. This trial was supposed to be 16 days long. We're now on to day 45 for mischief-related offenses here in Ottawa, right outside the courthouse today. Both Tamara and Chris will be appearing virtually, so the CBC over there, you can see there's a camera nested on one of the rare days, and I believe they're probably here for Chris and Tamara, unless there's another high-profile case of some sort. But unfortunately, they're not going to get any views of Chris and Tamara because Chris and Tamara are both being allowed to appear virtually now. You would think the CBC would know that. Maybe they're trying to get Greenspun, maybe they're trying to get Magus. We don't know. Both phenomenal lawyers. The defense teams have been amazing, and their job, again, is not to prove innocence. It is the Crown's job to prove beyond a reasonable doubt that the accused are guilty of the crimes being charged. The defense is proving in this case, sorry guys, we've got some sirens here. It's a busy downtown with a lot of problems because we continuously elect Liberals and NDP, so people are struggling on the streets like never before. We need a change and we need it quick, but that's another story. I mean, actually, I guess it's connected to this one, because when you think of what's happening here with Chris and Tamara being dragged through the courts, the anniversary of this, it started September 5th, I believe, 2023, and it is now, what, the 13th? Yes, it's Friday the 13th here in Ottawa, a very fitting day to end the longest mischief trial in Canadian history. And if it was not for the political overtones of what's happening here with Chris and Tamara, and goodness, I would love to see the communications between the Crown's office and politicians in both the government of Ontario and the federal government. Now, this always happens when we film here. There's always a fire truck that goes by. It never fails. Never fails when me and Chris film together outside. Never, ever, ever. Somebody's having some trouble because of Liberal NDP policies. Now, the overtones and undertones in this case with Chris and Tamara being prosecuted, this would not be happening. We would not be having a 45-day mischief trial if there was not political connotations here. If Chris and Tamara were Joe Schmo and Joe Blow, and they weren't representing people who stood up to the government, there wouldn't be 45 days of trial for mischief offenses. All right, there was no assault charged here. There's obstruct, there's intimidation, which usually intimidation is you prevent someone from doing something they're lawfully entitled to do. You don't stand on the truck, because as we know, this is also a Carter application case where the Crown is trying to have evidence against one applied to the other, and in this case that would mean that all the evidence tendered is basically for Chris Barber. Not to say that it's anything of any significance or import, but that's what's on the table. So the Crown put forward a Carter application so that anything Chris said could be used against Tamara, and vice versa, though there's nothing really that Tamara has done that would implicate Chris in any broader sense. And in that case, this is the first time in Canadian history, in Carter law, there's no case law, the judge remarked on it herself, she said she would have seen it by now, of a Carter application where the inherent unlawful common design, which is the step one of the test, that there's this conspiracy between the parties to do an unlawful goal, where the Crown's stated goal of the accused here is to have the government end the mandates. That is not a common unlawful design. That's not drug trafficking, that's not murder, that's not assault, that's not anything crazy. That is exercising our democratic freedoms in this country. So this is the first time Carter's being used in something that's not inherently unlawful. It's not a drug trafficking case. This is a protest against the government case. And where the Crown is trying to advance the Carter is in the later stages, saying the means in which they did it was the unlawful part of the scheme. Now, we can be argued, what's the party to an offense? How liable are they for other people's actions, and etc. And that's just something the Crown has to prove. But my point being here is that if this was not politically motivated, if the prosecution in this case was not politically motivated, if this wasn't Chris and Tamara, who set up probably the most successful anti-government protest in Canadian history, by that I mean a protest that went against a position of the government, if that wasn't the case here, then this would have been settled a long time ago. 45 days of court costs. I've heard estimates that this costed upwards of $5 million to taxpayers at least. We don't even know. I asked the Canadian press and the CBC some time ago, a couple weeks ago, after that estimate came out from an independent journalist, and I said, it would be a really interesting public interest story to know what this trial has costed Canadian taxpayers. And they said, oh, well, that would be impossible to know. So here's our CBC, our Canadian press, government-funded, government-supplied media, literally directly in the CBC and the Canadian press. I'm sure they get lots of kickbacks and funding and grants and so on of that $600 million, whatever it was, that Justin Trudeau likes to brag about at his fancy dinner parties. They don't give us good coverage because, we give them 600 million reasons to give us good coverage, kind of thing, right? So this is a public interest story to know how much this case has costed the Canadian taxpayers to prosecute, and the media basically, I'm like, that's a good public interest story. They tell me, oh, it's impossible. No, but we can go and break into the GoFundMe, to the Give Send Go, find people's addresses. That's in the public interest. But finding out how much the taxpayers have shelled out to prosecute these people, nobody cares about that. And it's impossible. We can't go and ask somebody. You know, we can't put a calculation together about how many days and then cost each day and then multiply that by the amount of days. That's impossible. You're talking about landing people on Mars here. That's where we're at with the state of media in this country. And in this trial, we've heard ridiculousness. We've heard about people buying earphones and then leaving the city, saying that they're in food deserts, but not knowing about local food repositories, stores that they could have gone to. We've heard about people testifying their places of businesses were invaded by fumes and horns. And not to mention that of the so-called civilian witnesses, the vast majority, I think all but maybe one, are involved in this class action lawsuit. So they have something to gain from having their cause forwarded in any court that can be used by the civil court later to give them a huge chunk of money. Basically, I don't like your protest, I don't like your politics, I want to get paid for it. But here we have ongoing in this country for over a year now, other protests that seemingly are treated totally differently, allowed to do whatever they want and nothing happens to them. But the second you stand up to the government, all hell breaks loose and you get stamped down. But anybody else, you do whatever you want, it's fine. That's for as long as you want to, whoever you want. That's it, that's all. This story has been ridiculous. This story has been political. This case has been political, and we would not be here today doing this if there was not political motivations. I would love to see communications between the Ministry of Justice, between the Ontario Ministry of Justice, between the Crown in this case, and I guarantee you there are contacts, and I guarantee you that's what's happening. That's what's happening here. That there's a undertone that, hey, you need to get these guys. There can be no negotiation. There can be no deal. I don't care how long it takes in court. Get Tamara, get Chris. And that's not what the Crown is supposed to do. The Crown is supposed to weigh the interests of the public versus the costs of the case versus all the other variables and make decisions on that. Oftentimes, they'll negotiate out of court ends to cases. We'll say, okay, we'll agree to do this, we'll agree to do that, we'll agree to do this, but not in this case. It's get them, get them, get them. And that is not justice. We saw it in Coutts, where the judge in the Coutts 2, Coutts 4 trial elevated the convictions of Chris Barber and Tony Oleanick from mischief and possession of a dangerous weapon to, they came here to shoot out with police, and gave them a 6.5 year sentence for Tony and 6 years for Chris Barber. And in that case, the jury explicitly found them not guilty of the main court charge, the main charge against them, which was conspiracy to murder police. But in his finding of facts, the judge elevated that in his possession of a dangerous purpose, the weapons of a dangerous purpose, to say, no, they're here to shoot police. And if you're there to shoot police, you're not there to shoot fingers off or do anything kind of, marksman skill. You're there, if you're going to say someone's there to shoot somebody, you're saying they're there to kill somebody. So here's the judge taking what the jury decided and elevating it. That's appealable. So we'll see what happens in Coutts. We'll see what happens here. The defense has done amazing. The Crown's evidence has always been weak. This is not a case where we have videos of assaults, where somebody's going up to somebody on the street, hitting them with something, maybe a megaphone, and we have a video of that. That's not what's happened here. We have a video of people saying, stay peaceful, come to Ottawa, and the Crown is building their case off of that. We have rights and freedoms in this country. Chris and Tamara acted within them, and they should be protected for it. As Mr. Greenspan said, in a contest between rights to property use and enjoyment and fundamental freedoms, there is no contest. Chris and Tamara acted lawfully, they acted reasonably. What happened at the time is all we Canadians with dissenting views were ignored by our government. They did the right thing, and it worked. It's not an unlawful conspiracy to have the government change their mind on something, especially when they throw letters from hundreds of thousands of constituents into the garbage can. What happened here in Ottawa was necessary, legal, lawful, and a perfect execution of our government, of our given rights here in this country. And they need to be upheld. From Ottawa, I'm Ray Glenn.